I mean, I don't know. She hasn't told us the time to go, so you can keep chatting with yourself.
Your conversation is more interesting.
Oh yeah, what the fancy folks are talking about. Principles.
We always have better principles.
Well, yeah. Specifically the enforcement principles.
You meant the
Okay, we're starting 2 minutes, 3 minutes, I guess.
I guess so. I don't know.
Okay. Louis is going to guide us as we discuss enforcement and compliance.
Okay, so that's we couldn't tell if the title of this was compliance or enforcement.
Yeah,
so we just add an and in between, and now you get both, which I think does tell us something about sort of the state of where things are, right? Like that compliance with licensing, enforcement with licensing, two sides of the same coin. And I think pendulums swing between years that we're talking a lot more about enforcement, years that we're talking a lot more about compliance, like proactive compliance. So hopefully we'll walk through that some. For those of you who joined us after lunch, I'm Louis Villa. I'm the General Counsel of Tidelift, which is a new VC-backed startup where we're helping support developers and support enterprise users of open source. The longer pitch is long, so I won't bore you with it. Previously, I've been at Mozilla and Wikipedia, and I'll let you each introduce yourselves briefly. And we had one speaker drop out, so Justin is a very last-minute addition to the panel.
Wow, I actually realized that
we all had a common affiliation at one point. I realized
yes.
it's been a long time. You didn't? And,
I never actually did.
Tiny bit of pro bono.
A tiny bit of pro bono.
Yeah.
There was a time in 2009 when we were all hanging out on the Upper West Side of New York City.
Yeah.
Also, in 2006, we were sharing the same office at least like 1 or 2 days.
Yeah.
Okay, which is all inside baseball for no one who knows that. So,
So we'll tell you about that right now.
My name is Karen Sandler. I'm the executive director of the Software Freedom Conservancy, which is an organization that does a good amount of the visible GPL compliance / enforcement work. And I am also a lawyer, and I do pro bono legal work sometimes for the FSF and GNOME. And before that, I was the executive director of GNOME, but before that, I was the general counsel of the Software Freedom Law Center, which was the context in which that previous getting to know you conversation happened.
Right. So my name is Justin Colanino. I'm an attorney at Microsoft in the Open Source and Standards legal group. Previously, I've been in private practice as a patent litigator, but I started my career for the first about year and a half at the Software Freedom Law Center, working with Karen right after Richard left. I got Richard's extension, so I used to get all these calls for Richard. And when I started out, I was doing GPL enforcement work, compliance and enforcement work for client Software Freedom Conservancy, and Eric Anderson represented them in the Southern District of New York in the Busy Box litigation.
And I'm Richard Fontana. I'm a lawyer at Red Hat, and I've been doing work around open source for probably over 10 years now.
Yeah, he does the Software Freedom Law Center too.
I was, yes, at one time.
Yeah, I just hung out there because one of my professors ran out there. I think he gave me some credit at some point. But so, you know, when I think about compliance and enforcement, there's sort of micro level stuff, like what are individual companies doing about enforcement and compliance, and that was something that came up a fair bit in the last panel. There's also macro level stuff, like what are the big picture changes in the environment. And so I think where I want to start is that I think one of the big changes in the macro environment in this past year, especially in the past few months, is that a bunch of big Linux kernel contributors issued a statement in November about how they're going to enforce their GPL copyrights. And that announcement was led by Richard. So Richard, why don't you kick us off by talking a little bit about that announcement and what you think is...
Yeah, so the Linux the Linux project has a thing called a technical advisory board. I think it's sort of actually technically an arm of, or sort of associated with the Linux Foundation, but it's really kind of elected by the developers of the project. And they came out with this enforcement statement, which was sort of signed on to by about 100 or so developers of the Linux kernel project as of, I think, recently. The statement says that the developers commit to applying the specific GPL version 3 termination provisions relating to cure opportunities to violations of GPL v2 license code. So the Linux kernel is licensed basically under GPL v2. GPL v2 has a kind of simple automatic termination provision. So the idea is to kind of give a more forgiving, kind of lenient termination enforcement policy to GPL v2 license code from the kernel. And then following up on that, Red Hat led a coalition of companies, including Google, IBM, and Facebook, announcing about a month after the Linux kernel statement came out that they were granting the same commitment essentially to all of their GPL v2 license and LGPL v2.1 or 2.0 license code. So regardless of project, they were granting the same commitment for all of their GPL, pre-GPL v3 license GPL code.
And so I assume you think that was a good idea. How impactful do you think that is?
So I think it's important to understand this is coming out of some specific concerns that have existed for a few years, primarily because of there's one litigator in Germany, a former contributor to NetFilter Linux kernel named Patrick McCarty, who is at least rumored to have brought a large set of cases using kind of tactics of enforcement that have been criticized by many in the Linux kernel community and in the community of commercial companies involved in using and distributing Linux. So the tab statement, the Linux kernel enforcement statement grew out of that. That these developers wanted to make some kind of statement about what they thought norms of correct enforcement were for their project. And then the motivation for Red Hat and the other companies in our little coalition of companies was very similar. So it's ultimately coming out of this concern about this one litigator in one country who's kind of caused a lot of angst in the Linux community over his enforcement tactics. And so we think it sends a really good message about what is the kind of the right way to do enforcement of GPL version 2, and in particular the idea that most acts of GPL non-compliance are inadvertent in nature, and that it's appropriate to give those who don't comply with the license a fair opportunity to correct those errors, which was historically the enforcement policy of the Free Software Foundation.
So Karen, I mean, you've been involved in an even broader attempt to, I might say, somewhat proactively bind the hands of GPL licensors to, as Richard said, essentially be slightly more lenient than the license formally requires. I mean, what do you?
Yeah, I mean, to give a little bit more background, a lot of this, the history of what Patrick McCarty had been doing, it was really shrouded in mystery. We talked about this a little bit last year, actually, during this name track. But there was the cases as they were brought in Germany have strong privacy components to them. So the defendants were unable to, or the public is unable to get it's not like in U.S. law where we have access to the docket and we can see all the cases. It was really we were relying on the defendants themselves to tell us what was happening, and people were claiming that Patrick McCarty was this really bad actor, and we just didn't know. And
can I step back, since this has come up in both of your? For those of you who are not familiar, Patrick McCarty is a Linux kernel developer who's been bringing a series of cases. He's the copyright holder in a small, though it's disputed exactly how small, portion of the Linux kernel, and he's been bringing a series of cases for 3-4 years now in German courts. So that's the information that we can't just search on.
Right, right. We don't really know who he's brought these cases against. I know from backroom discussions that some companies say that they've been approached by him and sued by him, and that I know that there have been some hearings that have been done, but it was all completely mysterious, and so and people were confusing these actions with the work that Conservancy did to enforce the GPL, and so we wanted to take things back from principles. For starters, people often mischaracterize what Conservancy does anyway, and think that we're really aggressive, or we've been we're trying to monetize, we're shaking up companies to get our big fat donations or something like that. And so we sort of took it back to first principles and said, what is it that we find potentially problematic about these actions that this person may or may not be doing, and what can we do about it to bring stability and take the risk out of the field? And so what we did was we decided to write down what our principles are in doing our own enforcement, and to really, and then to promise publicly that we would always do them this way. And we wrote the principles, and the FSF published them with us when we went public with them. And as they say, all the things that we were saying before about how litigation is a last resort. We say that the goal of these enforcement actions must be compliance and not monetization. That we will verify that there's a violation before we, as part of the process. And then we also included this provision that we thought that it was much fairer to include GPL v3 style termination over v2. And so we promised all of that in our principles document, and then we brought that so we published that for ourselves because we thought this is the enforcement we can stand behind, and that companies should know that that is what they should expect from us. If they get a letter from us that because they're not, we got a no source or offer going on, and we can't find someone to talk to, eventually we send a formal letter, and when that letter gets to legal, at least when they research us, they'll see, oh, they have principles about this, and maybe this is something we can talk about and not get scared, and also can help factor into the risk analysis and adopting the software. And so we did that, and I think that has had a really good impact, and I'm still not sure exactly how I feel about the Patrick McCarty stuff. There was a hearing just or 2 days ago?
Yeah.
2 days ago, right, and some of the members of our coalition were there, and we've had a lot of discussion about it, and it's all really fascinating stuff. I'm not sure, but a lot of it is based on speculation, but the good thing that's come out of it is that it caused us to at least write down what we do, and then it gave the NetFilter team the tools so that they could say to Patrick, this is what we believe, do you agree too? And if you don't agree, then we're going to suspend you from our team, which is what they did. And then further, that basically, set the playing field so that then other people can take the pieces of the principles that they think are the important ones, and they can do things like the Linux kernel enforcement statement or the covenant that that group of companies did, which I think is really cool.
Do any of you see more of that kind of stuff happening in this upcoming year? Like, are people going to break out other bits and pieces of it? And
I think everybody should just adopt it wholesale.
Well, I think
Are you going to do that?
Red
Hat, Microsoft.
I don't know about the principles wholesale, but we're at Red Hat we're continuing to try to get see if there's interest among other companies and kind of signing on to the same kind of commitment, and maybe doing it on a project-specific basis. So projects with multiple contributors contributing under the GPL or LGPL version 2, seeing whether projects will make that same sort of commitment that the Linux kernels make, or that certain developers in the Linux kernel project. So I think there will be some news about this in the upcoming year.
Oh, that's great. For what it's worth, then. I was going to say, I don't have an Etherpad because I think everybody's been really terrific at actually asking questions and not giving mini lectures instead of questions. So if everybody can keep that up, just throw up your hand and go for it.
I just wanted to make a comment to Richard, which you made Red Hat may not have realized the consequences of that statement, but everybody was like, wait a minute, Red Hat never enforced open source in the past, why are they saying this now? Are they now, oh my god, now we have 60 days to get compliant. So there was some misunderstanding or
Yeah, we
I think because of the commercial nature of Red Hat, there was suspicion about why you're making that statement.
I think that's fair. We did have a fact about this that included an answer to that question. So we made very clear this does not signal that we're going to go out. We're suddenly going to go out and start enforcing the GPL. And same thing with I can't speak for Facebook, IBM, or Google because I don't think they got the same. They didn't actually sign on to our fact. But certainly for Red Hat has lots of GPL and LGPL code. So it's a fair question. Red Hat has historically not been active in enforcement. The only real example of it is the defensive assertion of GPL kind of counterclaim in one patent, kind of a patent troll lawsuit that Red Hat was sued under a few years ago. So it doesn't signal a change in Red Hat's historic tendency not to get involved in enforcement itself. It is designed to send a signal about what the community thinks the proper sort of approach to enforcement ought to be. So if others do engage in enforcement, this starts to build a kind of record about what consensus view of enforcement policy ought to be in GPL communities.
But to be clear, for those who aren't into the nitty-gritty on this, it's not really binding on other folks.
It's certainly not binding on. It's binding on the companies that have signed on to the commitment, not binding on others.
And the Linux kernel enforcement statement is an additional permission to the license for the people who sign on so it's not a.
As is the core company statement, I would say.
would you, it's written differently.
It is written, so it doesn't use the phrase additional permission, as far as I know, but the phrase additional permission is used in the Linux kernel statement, but I think it's analytically, I'm not sure it really matters that much, but analytically.
Well, I think the,
Well, since you two jumped into the deep weeds of I'm gonna steer us into a different part of the deep weeds. So one of the cases, one of the litigations that was going on this year was Handcom versus Artifacts, which was a case in which Artifacts has some software called Ghostscript, which reads PostScript files, PDF files. Handcom allegedly infringed on it. What was interesting from the deep license nerdery perspective was that Artifacts alleged that the GPL was a contract and attempted to enforce on that basis, which is something that's relatively new. Most previous cases, and please correct me if I'm wrong here, most have been brought on a copyright infringement license theory. And
this case was brought on both.
Right. This case was brought on both, whereas most in the past have
only alleged a copyright violation of copyright.
although the topic came up in Jacobson.
That's true. It did come up in
Jacobson, which involved the Apache license, I'm sorry, the artistic license, I think they were both contract and copyright infringement.
That's true. That's true. So, I mean, does this reopen the age-old, is it a license, is it a contract debate? You guys went into the weeds first,
Yeah.
so, sorry, you all went into the weeds first.
Yeah, I mean, in the complaint to support either a contract theory or a copyright theory. And in other words, there was an allegation that the alleged infringer in the case, or the alleged contract breaker in the case, contract violator in the case, had agreed to the GPL when they had downloaded the software and, were not abiding by it. And so therefore the court held, that means that they read the GPL, they accepted it, and then they didn't comply with it, and therefore there's a contract claim. And the other issue there relates to whether or not those contract claims are preempted because, by the federal copyright law, because there's already a cause of action in the federal statutes for not complying with the copyright license. And the court held because there was alleged extraterritorial infringement, that both claims could stand independent of one another. Now, what does that mean for whether or not the GPL is a contract or a copyright? I think it means you can,
Why choose?
Yeah, it's allege both theories. In addition to the Jacobson case, there's an interesting case, not specifically about free software licenses, but the World of Warcraft case out of the Ninth Circuit dealt with whether or not particular provisions in a click-wrap license were a condition or a covenant. So the covenant would, a breach of the covenant in all in one document. Breach of the covenant was found under contract theory. A breach of the condition would sound under copyright. And the Ninth Circuit held that there needed to be a nexus between the rights granted by the Copyright Act in order for a breach of a particular provision to be sound in copyright. So in other words, there needs to be a nexus between the copyright rights and the provision in the agreement in order to maintain a copyright cause of action versus a contract theory. Right.
Right. And Sun Microsoft had similar language in there, which leads to some language in MPL. I won't bore people with that one.
Before moving on, I just want to point out that in the license versus contract thing, from a more global perspective, this plays out a little differently in different jurisdictions, and there was a really good panel at FOSDEM that Pam Chestic organized and was on that people should check out.
Right, yeah, there's a bunch of, for those of you who are interested in diving more into some of these topics, FOSDEM, which is a big conference in Brussels, has a bunch of streamed videos from their day-long legal track just a month or so ago. I don't think they have mine up yet because there was a series of technical glitches in mine, but yeah, that's an excellent point about the jurisdiction stuff. I wanted to tease out one more thing about before we get away from litigation specifically. We've talked about Patrick McCarty. There was in the in the hearing earlier this week, it was alleged that there's been nearly $2 million in payments to him so far from 38 different defendants. That's obviously a lot of money, a lot of interest. You've already mentioned that you think there's some hope of a good good outcomes from this, in the sense that it's brought some more cohesion around in the form of the various statements and principles that have been circulated. Any hopes of any other positive outcomes out of this?
You're all looking at me, okay.
Well, he was looking at you.
Yeah.
Go ahead.
No, go ahead, and I'm thinking.
I was trying to process your question.
Well, let me frame it a different way. There's been, and this is something you and I were just talking about over lunch, Justin. Traditionally, there's been one set of enforcers, like Free Software Foundation, Conservancy, very driven by the principles that are now codified. I will say, having represented clients on the other side of that, that the principles are very helpful, because they do help calm a client who is an inadvertent violator. You can point to these and say, hey, look, they're not trying to extort you, it's just this is how they do it. So that's very helpful. So there's that class of enforcers. There's the sort of Patrick McCarty class of enforcers. And for some time there was sort of Harold Velty. There's been some other sort of in-the-middle enforcers who aren't as profit-motivated as Patrick, but do seek to collect some damages and fees.
I think Harold was solidly in the FSF conservancy model.
Did he only? I thought at some point.
I think he did it as part of GPL violations network, and so FSF and conservancy will seek to cover their costs. Yeah.
So unfortunately, our missing panelist was going to take some of the heat of this question, because he has represented some clients who have sought some damages, not on the McCarty scale, but sufficient, frankly, to go slightly above and beyond merely paying his legal fees. And so I'm wondering, do you think there's a space in the ecosystem for this, Justin? You had a great answer for that.
I mean, I think that, the question is, essentially, I think, is private enforcement, that's for-profit, that brings lawyers to the table, and where the lawyers can make some money and the developers can make money, is that good? And I think David Philbor, who's not here, last year I think he made the point that it can be good, because the money goes back into the developer's pocket, and the developer can continue developing and making software and releasing it under free and open source software licenses. I think the issue with that position is that in order for kind of individual contributors, and it depends on a project by project basis, but take a large, robust project with many different contributors. If each contributor goes out and seeks rent in a for-profit way, that the private lawyer can bring private enforcement action, and they can make money off of it, then you get a royalty stacking issue, where things kind of go out of control, and it looks kind of like the patent troll problem, where you have the same one patent applied against multiple different companies, which generates a huge stream of revenue, and then people start going out and seeking out other thin slices of the property right and holding up large companies. I think that if you got into that type of situation where the patent troll type of problem was applied to open source and free software projects, what you'd end up with would you'd be scared. A lot of people would just be scared away, and it'd be really hard to, in the business case that we've been building, we've been working towards for the last 20 years, would be put in jeopardy.
And particularly scared away from, I think, use of the kinds of projects that have what we would historically have thought of as the healthiest, from a technical sense, healthiest kind of development process in terms of like size of contributor communities. Maybe such projects might have other problems, of course, but I used to point, maybe naively to some degree, I used to point to the Linux kernel project as kind of a model project, because it was so successful in attracting so many contributors, and it was sort of like the poster child for free software and open source. But this is now the sort of the flip side, that there's this danger of associating what we talked about as a kind of anarchistic kind of project with lots of developers as a sort of special source of concern about liability.
So these are really tough questions, and believe it or not, we get tons of heat from folks who are either working for companies or strongly affiliated with companies that tell us that Conservancy, whatever we do, we have to be really cognizant about adoption, and we have to do everything we can to make our lawsuits, or we don't even have very many lawsuits, if any, but our compliance work to be as company-friendly as possible so that more companies learn how to come into compliance and will continue to use free and open source software, even as an advocacy matter, to get more free and open source software being used. And then at the same time, we get tons of heat from individuals primarily who think that we are doing a terrible job because we're not going after violators who are been in violation for a long time, and because we're so soft, we're not as impactful as we should be. And so in some ways it's been a little bit of a relief to have a monetizer out there, because it's like, we've been doing the best we can, but we do enforcement at a loss, and it's been like a funny balancing act to kind of figure all this out. And I think the answer is I don't know where. We struggle to do the best that we can with the situation, and I think that the collaboration that is created in free and open source software, you cannot underestimate how much that is tied to this camaraderie and this willingness to work together. And a lot of it comes out of ideology, and a lot of it comes out of this corporate view of, well, we can use this free as in no cost software and collaborate with these other companies, and there's good that comes out of it. And I think that when you start having monetizers, even if it's in a small way, I think it impacts both sides of the equation. So I'm not sure. We at Conservancy don't think that you're community oriented if you are trying to monetize your GPL enforcement.
Right. Well, I mean, that brings, I think, to an interesting. This has, in some sense, been a very interesting year for GPL and open source license compliance generally, right? A fair bit of litigation, in particular, a fair bit of litigation, yet also simultaneously, I would guess that all of you own a device, at least one device in your home that is in GPL violation in some way, shape, or form, right? Not just GPL violation, many open source licenses, right? So the level of enforcement relative to the level of infringement, they're not, I don't know what the intermediate balance is, but they're definitely not in balance. I mean, do you think there should be more? I mean, how would you?
I absolutely think there should be more. I think the companies that are so present at events like this, I think the companies that invest heavily in their compliance infrastructure, that have heads of open source, that support counsel, they're investing millions of dollars in their own compliance. What I don't understand is this, as an industry, those companies should be funding community-driven enforcement so that we can, so that there's consequences for the companies who have a competitive advantage for not spending those millions of dollars on their own compliance. So, I think that we would have much better compliance, which would lead to better source code, which would lift the tide overall. I think we would be so much better off.
Either of you have any thoughts on? I feel like there is a right balance out there. So I just don't know. I don't know that we currently have the right balance. I mean, I can point to, say, the McCarty litigation as a bad thing, and I gave another talk kind of related to this topic a year or two ago, where I pointed to the BusyBox lawsuits as sort of an example of what I thought was the right sort of getting the right sort of balance out on GPL enforcement. So I think that the balance is you want and you do need a certain degree of enforcement to make sure that there's a level playing field for the companies and individuals who are involved in contributing to these projects, because it's not fair for some companies, and maybe this is sort of the point that Karen is making apart, not fair for some companies to sort of invest a lot of resources in compliance while other companies sort of get to benefit from a project like Linux without being compliant. On the other hand, I think that there's a point at which enforcement of certain types at least can start to discourage use of the software and contribution to the software, and that's sort of where I think you have to kind of find the right approach or the right balance.
Yeah, and that's why I think that funding community-driven enforcement is so important, where the first goal is that someone who's in violation today is tomorrow's contributor, and being exceptionally upfront about that. And if we all work together to provide the right educational materials alongside the community-driven enforcement, we would be in a completely different world.
Yeah, I mean, I think that in a lot of ways, the busy box litigation kind of sparked a lot of companies thinking a little more heavily about, how to do it and how to do it right. And, I think that's probably a benefit that came out of that, was that, this is a real license, and there are real people who, are impacted by, or there are real people who might come around and knock on your door.
This is amazing to me because at the time or shortly thereafter, as everybody here knows, the busy box lawsuits were decried as being terrible, a disaster for free and open source software. And what's amazing, it's like just like GPLv2 became beloved once GPLv3 had been released. So like, oh, if only we could go back to the busy box one.
Well, so let me, that's a totally correct and very darkly hilarious point. I want to jump back a little bit to something that Justin was saying, though, where people are thinking, I think, a little more about compliance, and certainly to shift gears and shift the discussion a little bit, one of the macro proactive trends that we're seeing is a lot more people investing in data and tooling in order to comply better for at least certain definitions of compliance. So we recently got, just as two examples, the Linux kernel got license information, machine-readable license information added to something like 70,000 files a few months back. And this was something that traditionally the Linux kernel had said, oh, we already know what the license of the Linux kernel is. We don't need more machine-readable information. That's just extra noise and extra work for us. So please don't do it. And then a couple months ago, that position sort of changed, and a lot of metadata was added. Let me give the one other example, and then just this week there was a project launched called clearlydefined.io, which is another initiative to improve metadata around project information, among other things, sponsored by. And it's actually hosted by the Open Source Initiative, so it's at opensource.org/clearlydefined if you're interested in finding out more. This is simultaneously tens of thousands of new files, and I think Clearly Defined is targeting the top 1,000 projects. Simultaneously, maybe not a very big tent. I don't know. What do you guys think about this trend towards more metadata?
I mean, I think it's good. I mean, from a standpoint of, when you're shipping binaries and you want to provide proper licensing information and attribution, you want to make sure that your licenses are compatible as they should be. Knowing what's in a code base when you're ingesting free software at scale, which is what Microsoft does, is extremely important. And so to be able to kind of get a clear overview of what is inside the packages you're using, because a lot of times developers will say, what solves my problem? If this solves my problem, this is what I want to use, and they won't go through and look through subfiles or dependencies, and having that known and defined is extremely helpful, so that it improves compliance, gives people the proper attribution, and also helps you keep track of what you're using. So if a security vulnerability comes along or anything like that, it's kind of all right there.
I'm a little skeptical about some of this activity. So in the case of the Linux kernel, what happened, what I think you're referring to is a kind of a standardization of how, on a source file basis, how licenses are sort of notated. Anyone using the Linux kernel project should have basically known that it's GPLv2 license, and yes, people who are kind of really obsessed around open source license compliance, and there's sort of a whole subculture of people who kind of annoy me who are like that. They will tell you that there's actually 200 different licenses in the Linux kernel, and you have to make sure that you're in perfect compliance with all of them, and basically it's GPL-2 licensed, and in any case, you should be building from source code and shipping source code with your Linux-based product, and you will be in compliance if you do that properly and in a kind of sort of self-auditable way. I don't know if you really benefit that much from having these sort of SPDX standardized license notices versus the kind of license notices that preceded them. So I've talked to Kate Stewart about this. She's one of the people who's been involved in this effort in the Linux kernel, and she pointed out that there's some Red Hat copyrighted files in the Linux kernel that say, copyright Red Hat 2000 GPL. And she said, don't you think it would be a good idea to change this to SPDX license identifier GPL -1.0? I don't. It's still GPL. It's if you have decent tooling, you will find it'll be identified by your tooling as GPL. So
who do you think has decent tooling?
Well, that's the part. So I think the value of the metadata is that we do. So this is really, in another sense, this is we step outside the Linux kernel, which is maybe a special case. This is all like really complicated. We have these code bases that are developed anarchistically to a large degree, and in a very informal way. And there's a complexity to the kind of licensing data that makes up any open source project code base. And the more that you can use tools to extract information from source code to make conclusions about licensing, I think the easier your compliance task is going to be. So I think to that extent, these efforts around metadata and improved information of that sort is valuable. If it's I don't know if we really have such good tools yet for that purpose, but if we, I think that's sort of a part of the objective. Is we need tools that can kind of reliably extract useful information from these very complex and in many ways informally developed corpora.
So you're skeptical of the tools, but you need them. I mean, that's even.
So I'm skeptical of some of the efforts around the metadata. So I think that there's a certain degree of bike shedding that occurs, and there's kind of, as I said, there's sort of a subculture.
For the lawyers who aren't experts, bike shedding.
I don't know if that's really the right term to use in this context, but bike shedding is sort of getting obsessed over trivialities. Is that I mean, it's not really trivialities, but it's sort of getting really caught up in maybe the less important aspects of open source licensing. So printing out. I know one person who's part of this subculture who will come to conferences and show these kind of phone book sized printouts of all these permissive license notices that they ship with their product. That's I think less important than getting these companies in the embedded device industry into getting them to kind of make sure that they're building stuff from source code, shipping their source code, shipping buildable source code. I think that's more important than getting really obsessed over some of these details of file formats and so forth.
I want to dig in on something, but Kevin was going to say something, I think.
Yeah, there was actually a presentation 2 days ago about that particular project about tags. So far, they've only touched 11,000 roughly files.
Oh.
And the reason they touched them is that they had no indication whatsoever in the file that was no license at all. And the DCO, which was for 2+ years now, specifically said, I have the right to give it under the open source license indicated in the file. There was no license indicated in the file. So that was the first reason that, yes, there's lots of people who focus on trivialities, but in this particular case, you could make a claim that there's no license indicated in the file at all. And so that's why they tackled those first.
And that's what's wrong with this culture. When the DCO was originally adopted by the kernel, it was not the general practice to put a license notice in each file, and everybody knew that. And the DCO has been used for 15 years or so with that sort of practice in place. And I don't think that's a good enough reason. I don't want to criticize it too much because there is some value to it, but but I think it's maybe not where the focus of efforts should
Yeah,
be.
I agree with that.
No, go ahead, go ahead.
Actually, let me take a slightly different tack here that all three of you may be able to, because Karen, certainly many conservancy projects are not the Linux kernel. You know, I think as you were just saying, Richard, the kernel is an outlier in a lot of ways. You know, some of the research we've been doing for Tidelift shows that even the most basic top level, what is the name of this license in, like, for example, in the Node ecosystem, something like between 5 and 10% of packages disagree between what GitHub says the license is and what the package manager says the license is. Like, forget looking at all the files, forget looking at each individual header, like just the very topmost level of license information is inherently contradictory. And so I'm wondering, like, in these more new ecosystems outside of the Linux kernel, what do you all see any best practices emerging, any terrible practices emerging? You know, where do you think we need to go with that?
Yeah, so people often associate the Software Freedom Conservancy with GPL compliance or GPL enforcement, but we have over 40 member projects, and they are under a variety of licenses. So many of our projects are under non-copyleft licenses. So just that in the way of background, we have, our projects are very, very widely licensed.
And in diverse technology stacks as well, with different traditions of how you do things. So.
Yeah, I do. What I've seen though is with what I see with copies. I'm trying to decide if I want to say.
Okay. Well, you know, Justin wanted to say something in the meantime. You can ponder.
I agree with Richard that, and probably Karen as well, that, you know, the most important kind of, you know, educational aspect to enforcement, or, you know, where we should be devoting our resources is, you know, education about, you know, how to build, how to ship code that builds, and that kind of thing. That said, I mean, permissive licenses are licenses, and we have to comply with them. You know, Red Hat has a different philosophy because they ship all their source. So you ship your source, you're in compliance, you're done, right? I mean, when your company...
It's a great recommendation for everyone.
Well, right. But when you have a business model that doesn't involve shipping source, right, you need to comply with the license. And in order to do that, you need to know what's in there, and you know what's going on in there. So, you know, a lot of these efforts, you know, there are a lot of different companies that rely on a lot of different projects and a lot of different, you know, permissively licensed projects to make closed source binaries and ship them. If they're all looking at the same project, you know, getting together and, you know, trying to figure out exactly what the proper attribution, what the right licensing is, and sharing that information in a centralized way, I think is a great use of resources, and it makes it so that we don't have these, you know, people spinning their wheels. So I think so it solves a particular problem that maybe Red Hat doesn't have, but it's one that, you know, other people do.
I totally agree with that. And what I was going to say is that I think it is valuable for these companies to get together and make this effort. I think for the free software projects themselves, their wider adoption is definitely a factor for encouraging that kind of effort.
Right.
But at the end of the day, a lot of the times it comes down to the focus being on the wrong things from a community perspective, because from our perspective, it's like the days when companies would provide black duck audits as proof that they couldn't possibly be in compliance. Like, a lot of times these initiatives do a good job of getting started, or a good job of, you know, they're tagging things so that if you have someone who's knowledgeable and you're doing the right thing, you'll be helped, and that's a good thing. But it doesn't really help the overall field of compliance. So it does help thread the needle, especially for companies that are using free and open source software to support their proprietary business models, and, you know, that's a fine use for them. But it doesn't help the whole field in the same way that it could otherwise. And there are other initiatives that might provide education on compliance that might help some of those problems. So I think it's a valuable effort.
Yeah.
From where I'm sitting, it's not it's not where I would focus my attention quite so much.
I want to shift gears one more time here. You know, Richard, the Red Hat blog had a great post a couple months ago about how licenses are really shared resources, right? Where a lot of information gets in there's the text of the license itself, but then, as I think the previous panel was pointing out, there's also a lot of wisdom and, meta things that build up around those. And you mentioned, while we were prepping for this, that Red Hat is, thinking about that a little more. Do you want to talk some about how or if that's impacting how Red Hat complies?
Well, it's not really focused so much on our compliance, but how we're seeing, it's really directed more to like what's going on with enforcement. We're looking at the McCarty enforcement, some of the rumors around McCarty's enforcement of the GPL. We're looking at what Conservancy is doing, what some companies are doing around GPL enforcement. So this idea of shared resources, licenses as shared resources, it's an idea that my coworker Scott Peterson came up with, and this is sort of my gloss on it, is that most of these open source licenses, in terms of like the actual use of the licenses, we're using 80%, 90% of open source free software code is using a small set of licenses. They are standardized licenses. They're not negotiated. They're sort of like contracts of adhesion. They're used across projects, across stacks, across technologies, and so that there's a certain benefit to that. Economically, of course, it's a standardization, de facto standardization, but there's also a kind of brittleness to it, because it means that when you start thinking about the risks of enforcement in the litigation system, at least, there's a danger of any particular court decision having an outsized impact on a really large community. So any court decision on any given kind of like negotiated contract might not have too much in the way of implications for contract parties in general. But maybe if they're using sort of semi-standardized language, it might. But with something like the GPL, a case construing the GPL is going to potentially affect hundreds, thousands of GPL licensed projects. And so if the danger is that what if courts get this wrong from a kind of community perspective? They're not likely to take community viewpoints into account. Maybe if the litigant, one of the litigants is sort of has community credibility, that's helpful. But in general, litigants to a dispute are going to be raising arguments that are not necessarily tied to how the community views licenses or what the interests of the community are. So that's the danger we see in kind of having any kind of increase in judicial kind of treatment of widely used open source licenses. So one way of sort of addressing that is things like the shaping norms around enforcement. So making sure that there's kind of a kind of expectation of forgiveness around GPL v2 license code. Things like the principles of community-oriented GPL enforcement are helpful. Maybe kind of getting other kinds of activities involved where you try to shape consensus on how to interpret the license, and so you start to kind of shape and potentially influence future courts and how they might interpret the license. So I think that's the idea behind the shared resources concern.
I like that idea, but it's kind of like a race, right? Because the thing is that at the same time as some companies have been arguing that we community-oriented actors should be very hesitant to litigate because the case might come down the wrong way, and that in fact you should avoid bringing a case at all costs because the risk of having a bad decision is so high. The problem with that is that if we do that and we try to establish these community norms, as much as we try to do that and publish principles, publish all these other things, corporate actors are going to have disagreements as they have done over the years. And it's only a matter of time before these cases are tied with messy fact patterns in ways that courts will just view as commercial activities. And it won't be set up with any possible ideological view. And so I think it's just no win. And if we don't move, I'm not eager to go to court, but I'm revisiting this shyness that we've had, or this communal fear of litigation, because I think if we bring these lawsuits with good fact patterns that are thought out, that are isolated in the questions they ask, then we'll get answers to those questions in ways that we can interpret and move on from.
Yeah, I agree to that to a large extent. I mean, I think we might disagree on what those appropriate cases are. So when I said that the BusyBox cases were sort of got the right balance, I think that's partly my view on that is because
there were no cert or offers?
Well, there were straightforward violation cases, I would say. I think that there could be other kinds of cases raising novel
For
interpretations.
those of you who have not been around this space for decades,
Oh, sorry.
the BusyBox cases involve devices sold through Best Buy, right?
Well, some of them.
That's
Some of
why
them.
it was
Yeah.
one of 13
There were 13 defendants.
Yeah, that included no offer of source code, no source code, like a very straightforward, classic black and white kind of violation of the licenses.
It was
I
one
think that's
filing, but it was really 13.
Yeah.
So very factually straightforward. It really wouldn't be a lot of disagreement in the community over, issues of GPL interpretation, I think, around
But there
cases like.
were at the time. And folks were really upset and really worried, and it feels entirely the same to me now as it did then. But now that we're looking back, hindsight is 20/20. But I'm glad those suits were brought because we had some results. And then we had that.
So some additional context might be helpful here, because I don't know if you guys can provide it, but I think what Richard's referring to is, in his view, the BusyBox case was a kind of straightforward, like someone took the software, put it in their product, and didn't even tell anybody about it, right? So that was that's what we mean by kind of a straightforward infringement action. I think Richard's saying that that's a very open and shut. That type of enforcement has good educational value. I think what Richard might be saying is not so good enforcement mechanism would be a case around an ambiguous term in a license agreement, an ambiguous provision that people have been interpreting different ways, and that ambiguity might be a feature rather than a bug in the license. And by getting certainty around it, it may harm the license environment. I think is the.
Well, I mean, the certainty may be in the direction we don't
that correctly?
We don't like. So
Yeah.
If one of the concerns around McCarty is that he is apparently, and this is where we really don't have good facts, unfortunately, but he's apparently raising what some people say are kind of relatively bizarre theories of GPL non-compliance, and so that's the kind of concern that we have. What if we got, and maybe the real concern is maybe more of like the litigant like Artifacts. So what if Artifacts asserts a theory of GPL non-compliance that really is out of step with how most of us in the industry who are dealing with distributing GPL code think the GPL ought to be interpreted in a very restrictive direction, because they have a kind of an incentive to do that, you might argue, because of their business model. So that's the kind of concern. It's not it's very far removed from the more straightforward kind of BusyBox scenario that I see of you ship a device, there's GPL code in it, you didn't provide any source code.
There were questions. Okay. But the main point that I want to say is that it's a race because there are cokinetics out there. I don't know if anybody read there's the complaint in Cokinetics, but it's just wild. It's a.
Which one was Cokinetics?
Oh.
It's the Panasonic.
Panasonic case.
Oh,
Yeah.
There's
Cokinetic. It's an amazing read.
Right. Yeah. I mean, in that case, please correct me if I'm wrong, but it was a third party seeking to enforce the GPL. There was sort of some antitrust thrown in. It is a very interesting read. The case settled fairly quickly. But yeah, it would have presented, I think it's exactly what you were saying about the fact pattern is so unusual, where it was a competitor suing with this sort of contrived third-party claim. And if a judge...
We're just completely out of control in those situations, and it's messy, and our community is really collateral damage.
I think that's what amicus briefs is for. I mean, my view on this is, trying to shape community viewpoints on licensing, probably won't make a difference to a judge. I mean, the judge is going to look at the license, they're going to read the license, and they're going to decide this is what the license means, especially, at least at the trial court level. And, and if that gets appealed, then there's an opportunity for amicus briefing. There might even be an opportunity, below before the trial court. I mean, for years we heard over, GPL v2, there might be an implied patent license, there might be an implied patent license. Then the Zimpleware case comes along, and the court is like, yeah, there's a patent license, it says use right there in GPL v2. That wasn't how I'd say most of the people lawyers in the community viewed GPLv2. They didn't think that there was a patent license, or there might be an implied patent license.
I think maybe I would characterize my position on that. For those of you, again, not super into the weeds on this, a lot of the older licenses, because they date back to a point in time where software patents were not necessarily even believed to be viable, don't specifically license relevant patents. They speak of use of the underlying code. And so there's been a question, implied patent law in the U.S., as well as in other places, as sort of a patchwork of mess of all kinds of things. And so certainly my position would have been, I can make a plausible argument that there's an implied license here, but I feel like going to a court would be a coin flip, right? And if you lose that, I think maybe what you're trying to say is that when you take a case like this to court, you're flipping a coin on behalf of the whole community, and maybe it comes up, there's a patent license. Maybe
that's what Richard's saying, and so don't flip the coin. I mean, what I'm saying, like, I don't want to be misunderstood. Like, Conservancy is not looking to be bringing lots of lawsuits. Like, that's just not what we're trying to do at all. But what I'm saying is that when you get to the instance where you have companies that are out of compliance and that after years of effort they still don't come into compliance and the fact pattern is clear, at some point, if you don't bring those suits, then the whole thing degrades. Because what we've seen is companies do everything that they think they can get away with. And if you never are willing to bring that lawsuit, then you may, it's that ambiguity that you think that you maybe benefit from the license, it's as if it doesn't exist at all.
So,
word might evaporate.
On that, like, forceful punctuation note, we've got a question.
So for somebody that's trying to be in compliance, that maybe is not as heavily into open source as the organizations that some of you are in, what are the things that trigger enforcement? And are there good resources that you would recommend? Because there's not a lot of open source litigation. Is there like good kind of resources to kind of follow, like blogs that kind of summarize ongoing major developments that happen in on-source analysis?
So for us, we try to do everything as transparently as possible. So we do publish, as we said, our principles, which sort of say what we look at if there's, the way that we get a matter brought to us is that usually someone has purchased a product who's a developer and looks at the product and can't get the source code and they want to do something cool with that product or something, right? And so they file a report with us and then we contact the company and we try to do it in a friendly, in the best case scenario, we once got a problem fixed in less than 2 weeks. That's happened like less than 2 weeks. So sort of like if you bring education internally and respond quickly, but I think a lot of it has to do with building the right procedures. So we've partnered with the FSF on copyleft.org, where we try to talk as extensively as possible about our interpretation of the GPL, and there are a lot of example enforcement actions, and we also publish what we think is an analysis of a pristine code candidate, so you can see what we look at when we try to evaluate it. So that's one resource that we provide. There are others too.
I would have said the same one.
And it's under copyleft itself, and so if you read it and something looks like it should be written better, you can please propose a patent. And we can help you do that.
That could be your first lawyerly contribution. I mean, I think I would add opensource.com log tag often has interesting news written by a variety of people. Many of them Red Hat employees, but not all of them. Mark Radcliffe does an end of the year roundup every year. It's exactly one blog post a year that's worth reading, but it's usually pretty good in terms of hitting the high notes. Heather Meeker just published a second edition of her book, which is a good one if you're ready to dive into something book length, because companies just getting involved.
Yeah, but I'd say book length is, I think she does a good job of distilling it as well. I mean, it's not like textbook length. It's like
really easy to flip
it's like
through.
book length, you know. You could read it in a few days. It's not heavyweight. I mean, it's a great overview.
Yeah, and reasonably, it was even still, a year ago I was still recommending people the first edition, even though it was probably 10 years old at that point. The new edition is still worthwhile. Oh, and there's one for your engineers who are interested. Van Linsberg wrote a book a few years ago that targeted more at explaining all these concepts to engineers in a way that's familiar and uses analogies that will work for them. That's usually again, it's touch out of date, but a pretty good read for, especially for some of your top engineers who are interested in it. Oh yeah, probably. Producing
Yeah,
open
it
source.
doesn't really deal with compliance, but it's a good introduction to how open source project development works.
Yeah.
And we just had a new edition come out of that.
And a lot of those names and materials are in the reading materials. So if you go to a link on our website, you can download a lot of those. And a lot of the books, a lot of the authors have been technical books for free, so you can download copies. So the LibrePad website, all the new materials are listed there.
Good, perfect pitch. Do we have time for one last question if anybody has one? Perfect. Thank you so much for having us.
Crystal clear. Thanks, guys.
We're not just making up this decision for the purpose of dollars.
I got 0.96. The judge is going to pick it up. What did you buy? How long does it take to get them? They hold them until the ACH can be cleared, but you get your price. $500 a day. Which is kind of annoying, but if I wasn't able to get more, I would have gotten floor prices. Right, exactly. Right, exactly. Like, it's like building a record over years. Too many listening. I mean, I like participating.
say it, it's like, the judge was just like, it says you, bang. Highly paraphrased. The Oracle Blueprint thing is really one of the
Yeah, like, I'm hoping you will, one of the PowerPoint technical aspects of it.
But I don't think that's right. I mean, even the context is the course of industry interpretation. That's like the legal realist thing I've ever heard. What have you done with the real thing? What are you talking about by the federal circuit? In Jacobson. Yeah, that, I don't, so they were trying to reach particular results there. Yeah, that's what courts do, and so you give them ammo for that. And you give them ammo in part by giving them a track record. If it's not on the health back over.
You talk with Bill, so.
Yes, we have all the adapters up here. But you know, what economy is it start at 4, or is it?
Start at 4, so until you write the,
Okay. We're just a couple of, we're just gonna, so I'll be right back.
yeah,
And that conversation is about that.